I'm meeting today with mediator Dan Day. And so, Dan, before you talk about the subject that you've chosen, I always do this with our guests. Would you please give people that would like to speak to you in the future your contact information?
Sure. It's probably best to reach me by phone at 801-676-1506. You can also find me on my website at www.d-daylaw.com.
Is that for Dan Daylaw?
Yeah.
That is. All right. Well, now, for those of you that might have picked up on this, Dan is not only a mediator, but he's also a practicing attorney, which is not unusual. In fact, in my estimation, it's probably best to use mediators in the divorce and family law setting who are lawyers, because divorce and family law is complex. In many ways, it's counterintuitive. And if you sit down with a mediator who doesn't have legal training, who doesn't know the subject inside and out, you could end up making an agreement that can't be enforceable.
Yes, mediators tend to stay out of the details of the agreement, really, but my preference would be definitely to have a mediator that is an attorney as well.
You won't tell people what to do, but you could tell people what they're not allowed to do. You'd say, hey, I understand what you'd like to do. The law won't allow that, but perhaps you could look at it this way or that way.
Well, yeah, particularly in family law, because there are some things the judge just can't do.
Yeah.
He can't, well, in rare circumstances, he can change the child support order, but generally speaking, you're just asking for more work if you do that.
So having an attorney that knows family law as your mediator is someone that can help you to get as close to your desired outcome without running afoul of the law, so that you don't have to end up going back to court or going to court only to find out that the judge has rejected the agreement you've made. But I'm jumping ahead of myself a little bit. So I wanted you to be aware of the fact that Dan is a practicing attorney as well as a mediator, and I have used his services before and found him to be really effective. And by effective, I define that as value for the money. We just don't waste time. Sometimes mediations, and I think you can probably touch on that a little.
Yeah.
Sometimes mediations can last too long. Dan doesn't do that. And Dan has a very, I think in the short time you've seen him so far, he just radiates calm and control, which is a feeling that I think most people would benefit from when going to mediation. So with that, and with that introduction, what are some of the things you'd like people to know about when they're contemplating mediation? What are some of the misconceptions they have? What are some of the things that you wish they would know in advance so that they could prepare for and make their mediation better?
Yeah, well, the biggest misconception that I see is people that think that the mediator is going to replace their judge and going to make the decision for them. And that's just not the case. Mediators are neutral third parties that help the parties communicate and brainstorm and look at different alternatives, do reality checks, and see if they can come to a resolution that works for both of them. It's just really frequent.
Will you take their testimony? Will you listen to their side of the story then? And then does the other person get to make his or her arguments to you next?
Sure. Mediation is a highly formalized negotiation, you might say. Mm-hmm. And I would expect parties to come to the mediation prepared to persuade the other side what they would like the outcome to be.
But they don't need to persuade you.
They don't need to persuade me, but it's useful to have a third-party mediator there to act as the conduit for making that argument. Sometimes, although I generally prefer that the parties stay in the room if they can cooperate, mm-hmm. But oftentimes they can't, and we have to go into different rooms. And I serve as the conduit to make the argument.
How does that work then? Because I think everybody could understand the idea of sitting around the same table, all talking to one another, with you kind of making sure that people take their turns in talking, that you can ask them clarifying questions. You might mention, being an attorney, also saying, by the way, Utah law doesn't allow that, so there's some other ways you may want to consider it. But then somebody might start to get angry and things like that, or there might be domestic violence, right? There might be a restraining order between the parties where they cannot be in the same room or something like that. Tell us what happens then if you're not all sitting around the same table talking and negotiating. How does that work if they're in two separate rooms? How do you do your job?
Well, I listen to what the other side has. We have those same discussions. They're just not together in the same room. And then I take their side of the dispute, what they have to say about it, and what offers that they might make, what arguments that they might make as to why the other side should be persuaded to see things the way they are.
And you just go to, you physically walk across the hallway or something to the other room.
That's right.
So it's kind of like it's kind of like the old childhood game of telephone, right?
Yeah.
Like like you tell them this, and it's like, okay, then I'll turn around and tell them that. Now that takes more time. Why would anybody ever want to do that then? What are the benefits? We've already talked about safety issues. Are there any other times when that might make some sense?
Well, yes, I would say the trend in mediation today is to do totally separate room mediation, caucus mediations.
Mm-hmm.
And I think the rationale for that, the rationale being used for that is that parties get together. I mean, there's a reason why they're needing a mediator in the first place. That's because they have a dispute, and it's often very heated dispute. And of course, as a mediator, what we want to do is we want to diffuse the emotion and get it down to a rational level. And oftentimes people get in the mediation and they just explode at the beginning, and the emotion increases instead of decreases, and we get further away from.
Let's talk a little bit about that. People get keyed up. There's a lot riding on it. The stakes are high. There's a lot of emotion, anger, betrayal, fear, anxiety, malice, vengeance, those things like that. And I thought it was interesting. You said diffuse the emotion. Sometimes I think people think, well, you're just a cold and unfeeling person if you want to defuse the emotion. But I think it's important for people to understand, what does it mean in mediation to diffuse the emotion? Does that mean we're saying we don't acknowledge it? We don't care? What does it mean to diffuse the emotion?
That's interesting. Yeah, I haven't thought of it much that way, but probably diffuse wasn't the ideal word. We want to try and separate out the emotion from the facts and the legal principles and the options that are available to resolve the dispute.
Said. I like that. It's not that their emotions don't matter.
Oh yeah, it really does matter.
It's just that when we're talking about reaching a compromise that'll eventually become an order of the court, a legally enforceable document, emotions don't play into that. Your emotions may inform the decisions you make, but the decisions and the discussion really need to focus on what will we agree to, as opposed to how do I feel about those agreements.
Yeah, it's impossible to divorce the emotion completely from it, but there's just a lot of plowing unnecessary field when we let emotions escalate too much. There's not a lot that we can do often about the emotions except to resolve the dispute. And if we can get the dispute resolved in rational terms, people can move on, and those wounds can begin to heal. But back to the point, there's an appropriate time to separate in a mediation, even from the very beginning. If emotions are going to drive the discussion completely, we probably ought to just say, well, let's let the mediator hear those emotions, because people have to get them off of their chest. That's part of being heard. And although the mediator is not there to be heard, we often serve that. The mediator is not there to hear, like in the sense of a judge would.
Yeah, not to listen to people and then render judgment.
Right, but people need to be heard, and they get a sense of satisfaction that they've been heard. Somebody that bears some sort of or sense of authority has heard them and has expressed those thoughts, emotions, reasons, and arguments to the other side, and therefore at least the other side heard it without being talked over the top of. Now,
and they know that the mediator understood enough to be able to communicate that, so that person should be, if you can understand the position and articulate it, then that person should be able to understand what you're telling them too.
right, and when we summarize the things, I'll be doing the same thing when we're in the same room. I'll often look at the other side and say, well, I understand this is what she's saying, and what's your reaction to that, and so
and
on.
It's funny, I know that we've been in some sessions where actually you will say, now, do I understand correctly? And you didn't. But that was the whole purpose, is saying, now, do I have this right? And you'd be close, like, well, not exactly. And that would also help us both to understand each other. Or you understood one party but not the other, and you were able to explain it better than one of the two attorneys or one of the two parties saying, no, I think what he's saying or what she meant to say here was this. Is that right? It's like, yeah, that's what I've been saying all along. Oh, okay, well, that party
Right.
just couldn't follow it. One thing that we talked about off camera before we went on is you said something about understanding the statistical, some of the statistical elements that are in play here when you look at settlement versus litigation. Did you want to talk about that?
Yeah, it's sort of my plug for mediation, and I'm no statistician. This is really not pure statistics, but if I were to ask you, if you had one dice and you were to roll it, what is the probability that you would roll a 6?
Is it 1 in 6?
1 in 6,
Yeah.
right? Now let's add it to 2 die.
Okay.
And if you were to roll 2 die, what is the probability of rolling double 6s?
It wouldn't be 1 in 12 then. I mean, that would be
Well, that's what
Yeah.
some people think. Well,
it's 1 in 6, or
some people think, well, it's the
the same.
probability of the next. Well, let me just give you the answer. The answer is 1 in 36.
Okay.
You multiply the probabilities of each.
Right. So see, yeah, I'm smart enough to know that 1 in 12 isn't the right answer, but I know that some people would think that, hey, double the dice.
No.
I have 1 in 6, 1 die. 1
Well,
in 12, 2 dice.
Let's do another example. Let's suppose that you're dealing with a alimony issue.
Okay.
How many elements are there to an alimony claim?
If I had to reduce it to its smallest number, I would say need on the part of the person seeking alimony,
So
and the
there's
ability
one.
to pay on the part of the payor. Now, under the current statutory scheme, we have several other, and I think, right off the top of my head, we're looking at fault, for example. That's
Mhm.
another one. So we have need, we have ability to pay, we have fault, and then within fault, we have different kinds of fault that one can consider.
Let's just
Yeah.
isolate it to fault for now.
Okay,
So,
so
we have 3.
three.
Are there others?
As I said, within fault, you have others, because then there's the
Oh.
question of, is there fault or isn't there? And if there is, then it's like, what kind of fault have you been able to establish or not establish? You've also got, pending right now at the time we make this video, there's also the discussion about whether one has given up career advancement opportunities to be a stay-at-home caregiver to children, whether career opportunities for advancement suffered as a result of the marriage or children or both. You've got a number of factors. You've got factors as to whether or not one contributed to the other spouse's education and career advancement.
Okay.
So,
Well,
yeah.
let's take.
You could take
let's
easily
take 4.
5. Yeah,
let's
4 or
take
5.
let's take 4. The need of the claimant, the ability to pay of the opposing party,
the question of fault,
the question of fault, and the question of opportunity to develop your career during the course of the marriage. And let's assign different probabilities. Now, we attorneys, we don't have any scientific way of doing this, but you'll find attorneys often asked, what is the probability of winning on this case? We get that all the time, don't we?
we do.
And the clients want to know that. I mean, that's kind of what an attorney, a real seasoned attorney, is valuable for, is he has a better sense of what your probability of
Simply
winning
because
is.
he has been or she has been a witness to this issue coming up again and again and again, and said, all right, well, on the question of alimony, under circumstances like yours, the probability of you getting what you want, they can do that based upon their observation of what's happened in the past.
Right. And it's not real scientific. And
Right.
I think studies have shown that we're not very good at it anyway.
Sure.
But so if an attorney, and it's very typical for attorneys to say, well, I think you're about 70%.
Because that makes people, hey, there's a 30% chance, that you have a risk, but it's better than even.
Right.
Yeah.
And the opposing side, the attorney will invariably be saying about 70% chances of winning on the other side. Studies have been done on that.
Yeah.
But let's go through each of these elements. Let's say I ask you, Eric, what's your client's probability of prevailing on the need issue?
Oh, well, my client has been a stay-at-home mom for 12 years, and they have 3 children, all under the age of 12, and she doesn't have a job right now, and he makes a lot of money, and they're living pretty much above their means. So yeah, her expenses and her need is high, and I can prove it. So I'm convinced she can get it.
So
Yeah.
what probability? 100%?
Oh,
Do you ever
well,
say
no,
100%?
I can't do 100%, Dan, because it's not in my hands. But I think that knowing what the judge is like and knowing what county I'm in, I would say I've got better than 70. I would say maybe 80 or 90. It will be hard. This is her alimony to lose.
Okay, let's say 90%.
90%, fine.
Now, his ability to pay. What's your probability of being able to persuade the judge that his ability to pay is?
He makes well
You're gonna
over
win on that.
He makes well over $100,000 a year here in Utah. That's good money in Utah, and he does not need $100,000 a year all for himself. We have proof of that because they have a family. They've got the 3 kids, so it's a family of 5. His ability to pay, I feel very confident of that. You want the odds on that?
Yeah, what's your odds?
I would say the ability to pay is 100%. And
Well-
just to be 95%, because I guess there's a chance I can get a judge that will not like my client's face or something like that.
Okay, yeah, you can never determine what it is.
Yeah, but I mean,
Well,
as close, pretty dang high.
Is there a chance he might come in and say, yeah, but I've got leukemia and I have all these medical expenses that are going to carry me into the future?
Well, there is a leukemia, but that was 5 years ago. Okay, maybe 90% now that you bring up the leukemia. I'd forgotten about that. But we feel pretty good about the leukemia.
Okay, so we got
Of course,
2.
then there's those medical bills that came along with the leukemia too. So not only does that impact his ability to work, but then we've got he's got quite a bit of debt. So that could have an adverse effect. And I know that our judge also battled cancer, so might be really sympathetic about that. So that could have an impact. And then I know that they are going to have to move out of the house, and then he will have some new expenses that don't exist now. So I guess that could further undermine the odds.
So you want to cut that down to 80%?
Yeah, I guess I'll have to cut that down to 80%.
Okay, 80%.
Yeah. Well, now that you mentioned it, I mean, she hasn't worked for a long time, but she does have a master's degree. She got a master's degree shortly after they got married. So
maybe her need won't be as high as...
Well, it's just her ability to support herself is not as good as somebody who maybe got married right out of high school or didn't complete college. So I guess that could take it down a little bit. She does live in her parents' basement. It's one of those mother-in-law apartments, so she's perfectly capable of living there. She's welcome there. Her parents, all their children have moved out. She's got a kitchen and bathroom, and there's room enough down there, so it'll be hard to argue that she has a lot of rent, if any, because she's been living with her parents.
her parents don't need to subsidize her forever.
But what they don't know is that her parents have, they've been separated for the last 6 months, and her parents haven't charged any rent.
Mm-hmm.
And I think if they tried to charge rent now, the judge might say, sure, you can't subsidize her forever. But by the same argument, it's like, if you can subsidize her for 6 months, you can subsidize her for 6 more.
Yeah.
So I guess that kind of goes down. Maybe we're down into the 60% category now.
All right, so let's say 80% for ability to pay and 60%
No,
need.
actually, like I said, 95%. Well, no, you're right, because of leukemia. Okay, yeah, 80% for that, right?
Okay, and 65% for need.
Yeah. Okay.
Let's just simplify this for now, just as those two. A lot of people would think that the probability of winning overall is the lowest common denominator, the 65% probability.
Well, sure,
win.
yeah. I mean, after all, that is my lowest odds. So yeah, anything
Right.
else is better.
But in reality, statistically, and this isn't real statistics because this is not like rolling the dice. Rolling the dice they're completely independent events.
This is the rule of thumb, albeit intellectually not a perfectly intellectually honest explanation.
Right. Because her ability to provide for herself and her husband's ability to pay are not completely separate from each other.
Okay.
There may be some interrelation between those two factors, but the lower percentage is not what the probability is. It's the probability of the two, the product of the two. So 85% times 65%.
Okay.
You got a calculator?
I do. So do you want me to multiply percentages or just 85
Right.
times 65?
Well, 0.85
Okay.
times 0.65.
All right, I will do that in just a moment here. So we got 0.85 times 0.65.
What's your probability?
Oh, now it's gone down to 55%.
55%. So when you have multiple probabilities and you have to prove all of them to win, your probability goes down. Now, alimony is a little bit, in family law, all the way around is so fuzzy
Yeah,
that...
right. These probabilities are, they're not scientific. It's even worse then because it's gut feelings.
It is,
And I think
right.
at this point it would be a good time to mention, because I know that one thing you'll hear from attorneys all the time, and these are not people that are being flippant. It's like, there are times I've gone into court thinking I can't lose, and lost. Sometimes I lost not because the merits didn't exist, but because I just had a judge who didn't like me or my client or was too dumb to understand. Other times I thought I had merits, and it turns out, by golly, the judge found a way to deny it, and it's perfectly legal. In fact, I might have been wrong, even though I thought I was right. Then there's other times when I think, yeah, we have a weak case. But we can, we're not going in bad faith. Let's make our argument.
Yeah.
And it's just like the judge says, sure, do you want anything else? And, my gosh. And so it really does happen. It really does happen. So
Yeah.
when we talk about the probabilities, that's really just, it's not scientific. It's just, I'm feeling really confident. And my confidence may be a result of good data, or it may just be because I have positive thinking.
Right. Well, and we as lawyers, we're trained to see things from our client's side. We try to see it from both sides, but we're their advocate. We're doing our best to put their best position forward. And so
Here's another thing I got to mention too. And if we were really playing devil's advocate all the time, a lot of clients would mistake that for, you don't believe in me. And so sometimes there are some lawyers, I think, that fall into the trap of they tell their clients what they want to hear so they'll stay employed.
I'm afraid that does happen. But a good lawyer should be informing their client of these types of things, that although I've been doing this for 20 years and I feel like your probabilities are better than not, there are so many factors that come into play, and we just did two. In a breach of contract, There's 5 elements. By the time you give even a high percentage to each one of them, you got to prove every single element. You're down to a pretty low probability.
They're still going to undermine each other. Yeah.
Yeah.
It's gonna...
And so when you take your chances with a trial, one, you're gambling a lot of money, and it's just my experience that you're better off trying to take control of that probability yourself, managing that through a mediation. If not a mediation, with negotiation,
Right.
and trying to get these matters resolved. But despite the risks of going before a judge, sometimes we just can't get it done, and that's okay. If you've tried, you've given it your best to try and resolve it through mediation, then we do have good judges.
Right.
But they're human beings, and I believe that by and large, at least in the courts in Utah, they're trying their hardest to do justice.
Yeah, there are exceptions, but they are rare.
They are
I
rare.
would agree with you there.
And going and having justice done is perfectly fine. But
Just as long as what you realize is it's real world justice. Justice means it's through the lens of an imperfect human judge making those decisions.
right, even though he's trying to do the best he can. I believe the last time I spoke with one of the judges at one of these seminars, they carry a caseload of over 3,000 cases
A year?
a year. Well, 3,000 cases all of the time are on their
open,
platter.
Yeah, that's what I mean. Open at one time.
Yeah, and
I'm surprised. I knew it would be a lot, but I didn't think it'd be that many.
yeah, they're very, very busy people.
I'll tell you one that I learned that you may not be aware of. I spoke to one of the domestic relations commissioners who said that I typically read, this is what he said, about 200 pages per day.
That's a lot.
That's a lot of each day, each business day, 200 pages.
Wow.
So,
But yeah, that's my plug for you to recognize that this business of litigation is risky. And although our clients, and when we have parties in mediation, are so convinced that they're right, they're always convinced that they're right. And that, I mean, you've heard it before, oh, no judge is going to do that. Well, they do sometimes do just that. Mm-hmm. And so to the extent we can manage that risk through effective mediation, it's wise to do so.
and even though it might feel like, wow, I've really compromised myself to death, and it does feel that way.
It does.
I wanted this. I thought I would get this. I deserve this. And now I've gotten half of what I wanted, 70% of what I wanted, 40% of what I wanted, and certain, whatever that is, whether that be the amount of time with your kids, the amount of money you get, which items of furniture, how much debt, whatever it is. What you're saying, if I think, I hadn't heard this before, but what you're saying is, even if you are compromising from where you were, in a sense, that's an arbitrary figure. It's very arbitrary. Yeah, we have some laws, but we don't start with actual dollar figures very often.
Right.
Child support, yes, but even that's malleable.
It is, yeah. But we shouldn't even be needing to mediate child support.
That's what I'm saying. Child support, child support is one that is fairly certain, but for the rest of stuff, it's really a matter of who tells the better story, who has a better command of the law, and the construction of the law. No two divorce cases are identical. So even if you've got older case law that say, well, this is really close, it's like, yeah, but there's always distinguishing features we can find.
Right.
That's interesting that you should mention that. So let me ask you this then. You've made a very compelling case for mediation. What are some of the things that what are some of the expectations people have of mediation that is unrealistic? Because I, as an attorney, will see people saying, well, I'll just go to mediation and get this worked out. And then the other thing is, how do people sabotage themselves when they come to mediation by failing to prepare properly? Those two things. So where do they give mediation too much credit when they've never tried it before? And what do they do to sabotage their chances of success?
And my first answer to that will, in some ways, answer both questions. A lot of people, like you said, want to keep lawyers out of it. And granted, lawyers are very expensive.
Yeah, I mean, we're both lawyers. We're not bothered by that fact.
Sorry about the phone.
No, that's all right. But we're both lawyers. But you know what I mean. We know we're expensive.
Right.
For most people, we're expensive.
Right. But I think the attorneys are critical to the mediation process. Coming without an attorney to a mediation, I still do that. I still help people resolve their disputes. But remember, my job as a mediator is not to craft a legal agreement for you. I'm not there trying to help one side get something and the other side get something. I'm trying to help the parties agree.
Indeed, you cannot advise the parties.
I'm not supposed to advise them. I think it's important to be informative.
Right. What I mean is, but you can't advise them as to what they should do.
Correct.
You can give them options, but and this is interesting, folks, because I see this happen to a lot of mediators where they say, well, hey, Eric's the one that mentioned, if I get a mediator who also happens to be a lawyer, well, I'm getting 2 for the price of 1. The person will mediate, and then when I ever need legal advice, I'll just say, hey, now put your lawyer hat on and tell me what you think I should do. That's a conflict of interest, because what may be good for wife is antithetical to what's good for husband. And so what you can say is you can explain, you can give legal information. Well, the code says it can be up to this. The code says you're limited to that. The code says these are the factors. You can do things like that.
I can inform about the law.
You can say, I've seen people in your situation do various things, and they've responded in different ways. But what you can't say is, no, what you're asking for is too low. You need to ask for more. No, what you're asking, you can't do, or yes, you should do this. I can't imagine you doing any better than that. Well, Dan, this has been a really great conversation because you've done an excellent job of giving us a good overview of the divorce and family law mediation process. Because for a lot of people watching this, they've heard about mediation, they've heard they've got to go or they're considering going. Yeah. They know a little bit about that. Thank you so much. I'm also grateful because you've done an excellent job of kind of getting into some of the theory behind it that has a real world impact on people. That whole thing about the statistical probabilities and stuff, I hadn't seen that before. And it's counterintuitive, but you're right. You really are taking bigger risks and bigger chances than you might think when you believe you've got a good odds on 1 or 2 things, but together they only drive the odds down. Right. So I appreciate you doing that. In finishing up, can we talk a little bit about a couple other things? 2 things. What are the unrealistic expectations people have about mediation? Either because they are too optimistic or too pessimistic, both. And then what are some of the things people do to sabotage their chances of having their mediation be a success? And let me define success. That doesn't mean that I got everything I wanted. Right. I define success for the purposes of our discussion as this was preferable to going to court and litigating the case to conclusion.
Yeah. Well, in a way, some of the answers to those questions would be the same. I think that parties come to mediation, first of all, with the misconception that the mediator is going to decide this for me. And oftentimes they don't come with a lawyer who's prepared or prepared themselves. And I think we mentioned earlier that when you come to a mediation, the purpose is to persuade the other side to settle. Not to drive them to court, but to persuade them to settle. And if you don't come prepared with some form of persuasion, then what's the point of being there? And I'm afraid there are attorneys that don't get the vision of mediation as a real means to resolve problems, and they're just going through the motions. Because, as we talked about, I think we didn't talk about this yet, it's required of every divorce and most domestic relations cases that you cannot go to trial until you've gone to mediation. Right. You talked about how you've got these judges with 3,000 cases, so even if you can technically get that waived, the odds of that happening are pretty low. I think both of our experience would say, hey, judges are going to say, even if it's not going to work, give it a shot, because at the very least, you never know till you've tried. Right. So some people will say, I've got a bad attitude. I'm the attorney representing one of the parties, or both the attorneys. We've got a bad attitude about mediation. We'll just jump through that hoop. We'll check that box. It's a wasted opportunity. It is. Even if you're cynical and say, well, I don't really expect it to work, you can gain some good insight about your enemy. It's always informative. Yeah, it's always informative. You'll gain insight into the strengths and weaknesses of both cases, yours and the opposing side. Right. It's also
80 to 90% of cases now settle in divorce and family law cases.
You just can't carry the weight of a case all the
Yeah.
way through trial.
And mediation has proven quite effective. I'll make this point and ask you, sometimes mediation has become so institutionalized, you almost get browbeaten into settling when maybe you shouldn't. So just keep that in mind. Sometimes people say, well, gee, I've spent so much time and effort on mediation, I'd hate to throw it out the window now. So they make a deal just because they don't want to, they feel like there's some costs are so great. It's like, I've got to settle, or otherwise the mediation was in vain. But with that in mind, then, what are some of the overly optimistic expectations people have of mediation?
Well, like I said, I think a lot of people come thinking that the mediator's going to decide this for them, and they're going to leave with it over with. But in order for mediation to work, the parties have got to carry the weight of this settlement. They've got to do the hard work. They've got to make the hard compromises. They need to come prepared to make compromises and know what their ultimate objectives are and what is most important to them and what they can shave away. And if they don't come prepared and they expect the mediator to just do all that work for them, that's not what the process is about.
Not only that, but the mediator isn't allowed to do that work, and even if the mediator were willing to shoulder as much of the burden as possible, there's only so much the mediator can do. The mediator doesn't know your history, doesn't know the other party's history,
Right.
doesn't know really everything that's at stake. What are some of the pessimistic views people have, the overly pessimistic views people have of mediation? You talked about one, saying that sometimes you'll get people that think, well, this is silly, and I'll just go through the motions. But there are other things you see people doing when they come to mediation, you think, oh, that's a shame, because they really have a bad attitude that's getting in the way of getting this done.
That's a bit of a hard question. The attitudes they bring to mediation. I think we may have talked about this earlier, but I fault a number of lawyers for this, that they don't see the value of mediation, and they're just anxious to get their position in front of a judge. I guess they have a lot of confidence that they're going to be able to persuade a judge, but the cost to get to that point is just unbearable for most people.
Do you see anybody thinking that mediation is just too much compromise? I'm being asked to compromise myself to death, and that's why I don't like mediation.
Oh, yeah. When you mention it that way, that I do periodically when people are discussing, either opposing counsel or people that call in, they are of the opinion that mediation, by definition, is compromise, and they don't want to compromise. And by agreeing to go to mediation sooner rather than later, they're taking they feel like they're expressing weakness in their position. But a good lawyer going to mediation would come prepared with a strong position to persuade the other side why they should end the litigation now.
That's a good point. I think we were talking off camera a little bit about, if you're afraid that a willingness or even an eagerness to go to mediation might give the other side the impression there's blood in the water, that's a fair thing, because it does happen sometimes. Sometimes people are desperate to settle because they have no other option. They're going to lose, or they're afraid they're going to lose, so they're trying to save their fat from the fire. But you made a good point where you said, if you've got a good case, and a good case means a case you could win at trial, a case you believe, which may not be everything the client wants, but you're like, look, let's offer them this, because if we go to trial, I'm confident we can get that. Why? Because we've come down. I've twisted my own client's arm so much that it's like, if we can't get this, then it's worth the fight, because if we can't get at least this in mediation, this is something I'll fight for.
Yeah.
And you go in and you tell them that, and you say, I have got, this is as low as it can get. I can't see how a judge couldn't do this.
Right.
I can't see how a judge wouldn't do this, because this is about as low as I can go, and therefore, in a sense, it's as equitable as possible. This is as fair to you as I think it is ever going to get.
Yeah, yeah.
You know what I mean? And I think people lose. You made a good point. Is that people, if you're strong, if you've got a strong case, you go in there and say, look at this case. This may not be the best case that my client desires, but is it a winnable case? I propose to you, other side, that it is. So you can either agree now, you can recognize and see the handwriting on the wall now, or we can spend X number of months and tens of thousands of dollars or more just to have the inevitable show up.
Yeah. Or even if you're in a weaker position, you can go into a mediation early on and you can say, this is never going to be resolved on summary judgment. It doesn't occur much in family law anyway.
But the same idea, it's like, look, I may have a weak case, but you're going to have to fight me a lot to get. In fact, that comes up in divorce all the time.
Yeah.
Where people say, look, I may not have the best case, but I can sure make you suffer and bleed money.
I would never do that as a lawyer, just for the sake.
But we see it. We see people do it.
We see it.
They may not be that blatant, but that's what's going on,
right.
Even though they have plausible deniability.
Right. But I certainly would go in and say, granted, you've got a stronger case than I have, but you might be telling your client you got 70% probability, and I know your probabilities are not that good. And I know that my client has probabilities too, and there's risk there for you, there's risk there for us. We ought to settle this case. And that's something you can do in mediation.
There's a win-win there without sounding silly, which is, okay, maybe you might have done better at trial, but when you factor in the additional strain and cost of going to trial, you didn't do as well as you thought anyway. And secondly, you settled, you got a good outcome. I settled, I got an outcome I can live with. You don't have to lose for me to win. You don't have to lose for me to be satisfied. That is very difficult in a family law case, where there's oftentimes you've got a power imbalance that wasn't present. And a lot of times people say, this divorce is an opportunity for me to get the pounds of flesh that I never got. And if you can rid yourself of that desire, you can say, wait, is this fair? Is the judge going to basically try to kind of come up with a half for you, half for me? Does this more or less come down to half and half? Half and half on the assets, half and half on the time with the kids, half and half on the debts. Or if we're dealing with somebody who out-earns his or her spouse by a factor of 10 to 1, it's like, are we in the right ratios? If the answer is yes, just because your spouse got something he or she's happy with doesn't mean you have to be unhappy with something that's satisfactory to you.
Exactly.
Well, I appreciate you taking the time to do this, and this has been really helpful. And I've learned some things about the mediation process, and I've gained a better appreciation for it and a better understanding of its limitations, which is also useful. So I hope you found this useful as well. Mediation oftentimes gets described in brief and sometimes overly rosy situations by the mediators who are out to sell mediation.
Yeah.
And it often gets talked down by the lawyers who don't want to go to mediation or see mediation as standing in the way of them doing their job. You've done a great job, I think, of showing the balance. And that's one of the reasons I like talking to Dan so much and why I've utilized his services as a mediator. Now, this isn't a plug, of course, because I interview many mediators. But Dan, you've done yourself proud today. For people that would like to contact you and perhaps think you'd be a good fit for mediating, would you give them your contact information one more time?
Sure, yeah. It's best to reach me by phone at 801-676-1506. Or you can find me on the internet at www.d-daylaw.com.
So ddaylaw.com. Is that right?
d-daylaw.com.
D-daylaw.com. Thanks again.
Thank you.